Well, hello, everybody. Welcome to another fun-filled edition of Coffee with Michael. Today, I get to welcome back Rich Falcone. Rich, many of you have seen him he's done so many webinars with me. He's done a few of these podcasts, and I get to bring Rich back. He's with the Littler Law Firm. Uh, today's topic is going to be on labor. So labor is different than attorney, employment, because labor really focuses a lot on the National Labor Relations Act, the NLRB, the National Labor Relations Board. It's more unionized stuff, but the NLRB has gotten into a lot of just other things over the last few years, and Rich's background is perfect for this. Rich does both employment and labor, but he digs deep into labor, and that's why I thought he would be the perfect guest to have back here. So, Rich, good morning, and you came back, and I appreciate that.
Well, thank you for welcoming me back, Michael. It's always good to see you, and I always look forward to these discussions, especially on this somewhat unique and very interesting topic of labor relations. It's fun stuff.
Yeah, and again with the changing administration, and again, full disclosure, I met Rich. God, I don't even want to say how long ago now because it's going to make both of us look older. We really are. But Rich and I have just hit it off. Rich has got a great sense of humor, and I like the way he approaches not just employment but also labor. It's a very calm approach to things, but because of his knowledge and expertise, he's able to give really good insight and then just kind of give some tidbits on, okay, and these are the things you need to look for. So, with that being said, we are going to talk about, I don't want to get too political on these things, but I mean, that's a part of life, especially in business. And we have a new administration in here. This current administration was trying to shake things up at the NLRB, which would have, I think, big impacts with employers. But if you could, Rich, take us back because you were talking about a little bit of history, so we have a better idea of what's going on, a little more context. So why don't you start where you want to start, and then we'll just go from there.
Sure, be glad to. Yeah, in history, which was my major in college for what that's worth. But I love history, and history, as it relates to what we're talking about today, is important because it puts into context what we're going to be talking about today. So taking us back to 2008 and onward from there, and that's when President Obama was sworn into office. And up until that time, the National Labor Relations Act, the National Labor Relations Board was pretty staid, so to speak. There wasn't, much excitement when it came to labor relations. It was the basic fundamental stuff that had been going on since I think it was 1933 or 1934 when the NLRA first came into existence. But during President Obama's administration, things were really shook up and changed. And we were caught by surprise, we being, attorneys and human resource professionals in the labor arena, because President Obama and his administration implemented, if you will, an aggressive labor agenda. You may recall going back to there was a decision called Purple Communications by the NLRB sometime between, oh gosh, 2008 and 2016 when President Obama exited the White House. Purple Communications pretty much said that unions and employees can have access to the employer's communication systems, largely emails, because that was the mode of communication during that time. And that was a big surprise, that the NLRB would allow unions access to a means of communication that was, if you will, proprietary to the employer. Another example would be employee handbooks. I mean, we were almost aghast that the NLRB was, sticking its nose into employee handbooks and provisions in employee handbooks that the NLRB decided were violative or potentially violative of Section 7 of the National Labor Relations Act. That's the Section 7, that provides the rights to employees to engage in concerted activities with regard to wages, hours, and other terms and conditions of employment. And the NLRB said, there are provisions in employee handbooks, like employee access to information, for example, that, that we believe may violate Section 7. And so that had to be changed, as well as other provisions of the employee handbook. So that's kind of the history, the background that then led us through the Obama administration. Then, of course, Michael, as we know, in 2016, President Trump and his administration came in. It became more, if you will, pro-management oriented. And so we had that four-year hiatus where there were more management decisions, which pretty much rescinded or attempted to rescind a number of the Obama administration policies and actions of the NLRB. Then, lo and behold, as the political pendulum keeps swinging back and forth, we wound up with President Biden. I almost said President O'Biden because I kind of facetiously say that because with President Biden, he brought back in what President Obama had implemented with the NLRB. In fact, it even got more aggressive. And President Biden had a general counsel by the name of Jennifer Abruzzo. And she pursued a very aggressive agenda that was pushing union policy and agenda, pro-employee policies and laws and decisions. And of course, with the new administration coming in, that meant that President Biden, I'm sorry, had the opportunity to implement his board members. So it was a 3-2 majority for the Democrats, and General Counsel Abruzzo, implemented her term. And so, from a history standpoint, that's what we were dealing with, and which kind of brought us to, if you will, almost the present when President Trump took over in January of this year. So that's the history that I wanted to, put out there to kind of put this in context and suggest that leads us to talking about what's going on now and the changes that President Trump is attempting to implement.
Yeah, I mean, and it is interesting. I didn't even think about it until we were chatting before we went live here. But past presidents, since I was younger, there were definitely differences in policies that one administration would have from the other. But I never really saw a lot happening with the NLRB, not until Obama got in, and then you started seeing a lot of reaching into other areas. And so okay, so let's go to this next level then. So what has been happening? What are some of the big things that have been happening within the last couple of years? What were the Biden administration policies that were taking effect? Because I remember, and I haven't really looked into it for a while because it kind of died off. But I know that there are things in place to make it easier for unions to gain footholds, right? I'm blanking on the name of it now. This act that they were trying to push, maybe they pushed it through, but it was so much easier for unions to say now, okay, you have a union now. They didn't even have to go through some sort of an election period, if I remember correctly.
Yeah.
But now has that been put on hold? What's happening?
Yeah, yeah. So just a little bit, if I could, on what I refer to as the political machinations, which
Yeah,
bring us
definitely.
to the present, where those changes that you just alluded to are occurring.
Mm.
So when President Trump took over in January, he made a couple of changes, which I refer to as political changes. He fired General Counsel Abruzzo. Her term was scheduled to end this summer, some point this summer. I forget the exact date. So he let her go, terminated her tenure as general counsel, and appointed a fellow by the name of William Cohen as acting general counsel. And the general counsel, just kind of like a general counsel of a corporation, is the legal lead of the National Labor Relations Board. He or she is implementing the agenda and guiding the agenda and setting the agenda, quite frankly, in conjunction with the administration. So Cohen is currently the acting general counsel, but on March 25, President Trump nominated Crystal Carey, who's a very young lady, certainly young from my perspective. She's in her early 40s, and she's going to be going through the congressional process of being interviewed, evaluated, and voted upon to determine whether she's going to get approval to come on board as the general counsel and take over for Cohen, who had taken over for Abruzzo. So the other thing that Trump did as a part of the political machinations was he fired Gwen Wilcox, who was a member of the National Labor Relations Board. And actually, her term wasn't going to expire until August of 2028. So she could have still been there. Now, historically, what has happened is board members, when a new administration comes in, understand I may be terminated, I may be asked to leave, and typically they just move on. Well, Ms. Wilcox decided she wasn't just going to move on, and filed a lawsuit to try to prevent that from occurring. And this has taken out a story all its own. So on March 6th, a federal court reinstated her. Then on March 31, an appellate court issued an injunction stopping her reinstatement. April 7, what we call an en banc panel of that appellate court said, nope, we're going to reinstate her. And then yesterday, Chief Justice John Roberts issued a temporary pause, a temporary injunction, and said, I'm going to stop the reinstatement of board member Wilcox, and the Supreme Court will take it up. So that is kind of in flux. And the important part about that is there's only 2 of the 5 members of the NLRB who are sitting, who are in place and can take action. But under the law, you need 3 members for a quorum. So nothing can happen. The board can't do anything. So that's the political machinations that we are going through presently. Getting to your point about, okay, what changes, can we anticipate, what's going on? Getting into the nitty-gritty here. The acting general counsel, Cohen, has rescinded a number of actions, memos, courses of action that former general counsel Abruzzo had put in place. For example, Abruzzo had a provision in place that put on hold severance agreements and confidentiality agreements, non-disparagement provisions in those agreements, because she believed and the NLRB believed that it was violative of the employee's Section 7 rights. And so putting that in context, when we have a severance agreement, a lot of times there's a confidentiality provision and non-disparagement, which means that when you go out the door, you can't reveal information or events that occur during your employment with your employer. You can't disparage the employer. And Abruzzo and the NLRB decided that that could violate Section 7 of the National Labor Relations Act because it prohibits basically the employees or former employees' right to free speech. For example, to go out the door and say, I just left that place. It's a terrible place to work. We don't get a full lunch break. We don't get the tools that we need to do our job. That technically could be a violation of the non-disparagement provision. And so Abruzzo and the NLRB said you can't do that because it restricts employee Section 7 rights. Well, when Cohen, acting general counsel Cohen came in, he rescinded that memo. And so that now is on hold. We don't know what's going to happen. All we know is that, well, technically, legally, we know that it would not be a violation of the National Labor Relations Act for an employer to require an employee to sign a confidentiality and or non-disparagement provision going out the door. So that's one change that occurred. other changes, you may have heard, Michael, I know we've probably talked in the past about captive audience speeches. Uh,
Yes.
yeah, which are is an interesting thing in and of itself. And the way a captive audience speech comes about is we have elections, as you know, under the National Labor Relations Act, when a union is trying to get its foot in the door. And one of the things that employers do is the day before the election, 25 plus hours prior to the election, um, employers typically would have what became referred to as captive audience speeches. And what they would do was a mandatory attendance. You and I would get a memo, Michael, that said, be at, the auditorium or the conference room at 7 a.m. on tomorrow. The CEO wants to have a discussion. It's an all hands meeting, and you have to be there. It's mandatory. So we'd show up for the meeting, and the CEO or VP of HR or whomever would talk to us there. This is why you were asking you to vote no on this union election. We've provided this, we've got good wages compared to our competitors. This is what we're doing. And you're trying to convince the employees with the upcoming vote in the next 25 hours to vote no on the union. Well, during the Biden administration, General Counsel Abruzzo and the board said that mandatory captive audience speeches violate Section 7, that you can't require employees to mandatorily attend those events. They felt it was overbearing, violative of Section 7 rights, and so they rescinded that. Well, one of the first things that Acting General Counsel Cohen did was came in and rescinded that memo, and so that was another change that's been made since President Trump came in. And there's several more that I can go through, but why don't I take a break and turn it to you and give
Yeah. So it's
your
it's a
thoughts
lot
on
of
it?
gamesmanship, isn't it?
Yeah,
Just
it is.
back and forth. And then, one of my frustrations over the years with unions in particular, and I do have to say, I mean, just up front, that at when unions first started, I mean, I think, definitely a need for them, right? I mean, there were no protections for employees, some of the harshest working conditions. So, unions had their place, but I think it's evolved to a point where I think most employers care about their employees and they want to do the
Yeah,
right thing. But through the NLRA and the and because of the NLRB overseeing this, because of certain, and again, it's always a 3-2, right? You either have three Republicans, two Democrats, or three Democrats, two Republicans. So you always know which way this board is going to go.
yeah,
But when we talk about things like free speech for employees, right, violation of Section 7, this stuff, what irks me most, it always seemed to be going, it was always a one-way street. They always looked out for the employee, so the employee could go out, disparage. But where is where does disparaging a company, when does that turn into defamation and libel, right? There there's protections for one, but not for the other. And I think if the NLRB was going to be fair, and I do think it needs to be fair, because I still every now and then run into an employer, and I think, you know what, you probably should have a union here for your employees because they're just not taking care of them. But
yeah,
but for I think there would be so much less pushback if it was just a fair presentation of the NLRA for both sides. And yeah, the captive audience thing always frustrated me because, again, the employer wasn't able to give their side of the story. And hey, look, we take good care of you.
yeah,
They should be able to market themselves to the employees. But
yeah, yeah.
anyway, that's my
Yeah.
2 cents on that.
Yeah, there have been times that mostly I've thought to myself, but I've said in doing presentations like this that if an employer winds up with a union, they deserve it.
Yeah.
And which is offensive, if I were to say that to one of my clients, but it's true. If you're not, and what I've always advocated with employers, and as you know, we exclusively represent management employers, is treat your employees right. Um, and in any number of ways, obviously wages, benefits, um, do a survey. What are other employers in your industry, in your locale, paying employees? And at least meet and try to stay above that. What other things, and this is where you get someone like yourself, a creative HR professional, to come in and say, what could we do to make this a better place to work? You do employee surveys. What do the employees like? Is it would if we have we stop today on Friday at 3 o'clock. We're going to have a get together, and you got to be reluctant, I guess, to provide alcohol because of the risks there. But maybe you have a non-alcohol related party. We're going to have hot dogs, hamburgers, steaks, whatever, a barbecue, something like that. Employees, would that be a good thing? Or would you prefer that rather than have the barbecue, that we let you go at 3 o'clock on a Friday? We let you go an hour or two ahead of time, things like that once a month, right? But things like that to stay ahead of the game and ingratiate yourself with the employees. So be a good employer so you don't wind up with a union. And then,
Yeah.
your reference to, the the lean sometimes that's more employee friendly than it is toward management or employers. And one of my partners, who I'm still work with, but we go back to the 1980s, and he would always, I'd be lamenting about an NLRB decision, and I can't believe they ruled in favor of the employees on this. And my partner, Dick Leisha, would say to me, he said, Falcone, remember, it's the National Labor Relations Board, not the
That's true.
National Management Relations Board. And he
That's
was
true.
absolutely right,
Yeah.
because the NLRA was put in place back in the 1930s because, Michael, of what you referenced earlier,
Yeah.
some bad apple employers
Yeah.
who just weren't treating their employees right, and the NLRA was put in place to try to rectify that. Um,
Yeah,
so
I would say, I do agree with you on a lot that, and again, 10 years ago, if a union was really making inroads to an organization, I would say, employer, you really need to look at yourself. I mean, what aren't you getting done?
yeah,
I'll say two things on that. One, I think there are still really good companies that have unions pushing, and it's because of specific managers or supervisors. And so you got to train these people, right? Because they're the
yeah,
ones that are just not doing the right thing.
yeah,
And secondly, from an employer standpoint, the quality of employee that they're getting, right? Because even if I was talking with a client just yesterday that this company just bends over backwards for their employees, pays them so well, bonuses them out as much as possible, but it's never enough, right? The minute the employer says, well, okay, we're unable to do this time, um, go above and beyond. It's like, well, why not? Oh, we're becoming that kind of a company now. And again, there's unfortunately an attitude with a big section of the employee base these days that I think works against good employers. And so a lot of employers I see doing the right thing. They have good managers in place, but there is definitely two sides to it, and that really drives my frustration with the NLRA. Yes, it is a labor association or agency, but I think it's important for them to understand that there are a lot of good employers as well, and maybe some of the employees may need to have a little more critical eye looked upon. So
yeah, and key word you mentioned there is training,
yeah,
of your supervisors, because they're your front line, right? They're the ones they are the employees who are dealing day to day directly with the supervisory employees that they supervise. And when surveys are taken, and I've seen any number of surveys where employees are asked, what would you change here at the company? Where do you see the problem issues? We often think, well, they're going to say wages, they're going to say benefits, they're going to say PTO, vacation time, that sort of thing. Often the number one thing is, better supervisors,
Yeah.
or, identifying it as a bad supervisor. And a
Yeah.
bad supervisor, it's like a cancer. So the training is key, as you said, and in conjunction with training is having an HR team with its ear to the ground. So what does that mean? Meetings with employees, employee circles, small meeting groups. Something simple as a suggestion box, a complaint box, an anonymous system. I say box because I'm an old guy, and there was a box you would drop something in. Now we got a system, which in fact I'm working with a client who got the electronic notice from an employee about a complaint last week, and so we've got that mechanism and mechanisms like that in place. Not only the mechanism in place, but equally as importantly is being responsive to those complaints that come in the door, and addressing it. So a means by which employees can anonymously, make complaints that you can immediately address, whatever it may be. Maybe it's a bad Apple supervisor, but just being aware of what's going on and providing your supervisors training, not only training on being a good supervisor, these are our rules, these are our policies, this is how we treat people, but to have an eye out, an ear out for, is there any activity meaning union activity that's going on? Are employees suddenly complaining about things they didn't complain about before? Because
Yeah.
that could be a sign that there's a union who's knocking on the door and interested in trying to organize your employees. Um,
So
yeah,
yeah, and so you mentioned a couple things earlier. Were there any other issues that you need to bring up? And then let's get into what can employers do, right?
sure.
To stave off any kind of organization effort.
Yeah. So a couple other changes that I think are going to be significant with the new Trump administration. Um, Under President Biden, there was a decision called CEMEX, CEMEX, and it had to do with elections. And so a little bit of history on elections. When President Obama came in 2008, at that point in time, there had been a practice with elections under the National Labor Relations Act, which had basically been in place since the 1930s and hadn't changed. When President Obama came in, they implemented what was referred to as quickie elections. Um, in the old days, uh, an employer would get a notice of an election from the NLRB, and that might be the first time the employer became aware that the union was knocking at the door. Well, the employer usually would have up to 42 days before the election. The NLRB would go through a process. We'd set the election. It would set the election. And the average time was 42 days from date of the filing of the petition for election. So that gave you over a month to run a campaign. You bring in an outside persuader, you bring your HR team together, your supervisors and managers together, you organize. We're going to prepare a campaign. You get out, you have meetings. And so you got more than a month to get your message across. With the quickie election under President Obama, he cut it in half. So we would get to an election within 21 days or less than the filing of the petition. So you as the employer, you're caught off guard. Oh my gosh, an election. We're going to have an election in less than 3 weeks. So you try to gear up for that election. And so quickie elections had been in place until President Biden took over in, what was it, 2020. Um, then the NLRB came down with the CEMEX decision. And so what CEMEX basically held is that a union, it can demand recognition by an employer by showing the employer we have a majority of our employees who sign these cards. They want us to represent them. The employer at that point had two options under the CEMEX decision. One was, okay, you win. We recognize you as the union. We'll bargain. Or the employer would file what would be called an RM, or employer or management petition, to test whether there was indeed a majority support of the employees. And basically, the employer, by filing that petition, would say to the NLRB, we have reasonable doubt that they have a majority of the employees, and so we want an election. And then the election would occur. Now, if the employer either failed to file the petition or failed to recognize the union, an unfair labor practice charge would be filed against the employer, and the NLRB would say, you now have a union,
You got the union.
Mr. or
Yeah.
Madam Employer, and there you go. So that is currently, quite frankly, the law. But what we fully expect is that at some point, President Trump, through either acting General Counsel Cohen, or the new general counsel, assuming she's approved, are going to change that. What they're going to change it to, who knows? But that is a change, and a significant one. I think that's one of the more significant changes that we can reasonably anticipate.
Okay. Okay. Well, I hope so, because that's just tough. It's tough for employers. But so so from here, and again, I think it's so important for every employer. You think, oh, a union will never come here. We're too big. We're too small. But remember, micro unions, units, right? I mean, it can be a department within a company that
Yeah,
gets unionized first. And this is why, again, it's so critical that you're looking at your supervisors, your managers, because you may think we've got a great team overall. Yeah, we have one or two, problem managers that create havoc within the departments, but overall we're good. Well, those are the one or two departments that may organize first, and from there it could spread. So be
yeah,
very, very careful. So what are some of the things, again, you mentioned earlier, get a pulse, right, of your employee base. Look at your supervisor group. What are a couple other things that they can do now? And if they get wind that a union is trying to organize there, after they call you,
Mhm.
what's going to happen?
Yeah, yeah. Typically, what happens, when an employer believes that a union is sniffing at the door, they'll call us. Um, we'll get we'll have a meeting with them. We'll meet with the management team to determine, why do you believe there's a problem here? Um, we can meet with the supervisors as well. We can train the supervisors to prepare for an election if it appears that, that may be imminent. And we typically would recommend bringing in what we call a persuader. And a persuader is someone who actually registers with the Department of Labor, and he or she um, uh, it typically, particularly in California, is bilingual because a large part of the working force is Spanish speaking. Um, a persuader is trained in, of course, under the National Labor Relations Act, understands what the National Labor Relations Act is about, understands particularly what an unfair labor practice could be, and so they know not to tread in that area. But a persuader is somewhat like a inspirational speaker, if you will, with knowledge of the National Labor Relations Act. and human resources, who comes in to meet both with the supervisors to participate in the training of supervisors on the do's and don'ts of what you can do as a supervisor under the National Labor Relations Act. You can, for example, threaten an employee, you can't interrogate an employee, you can't make promises to an employee, you can't survey an employee, what we call tips, threaten, interrogate, promise, or survey. So we train, the persuader helps train the supervisors. And importantly, the persuader meets with the employees, typically in small groups, and has a chat with them. What's the issue here? Where you understand there's a union that may be trying to get in the door. Why? What's going on here? Is it a bad supervisor? Is it the pay? That sort of thing. And the persuader works in conjunction with human resources for the company. And then myself or one of my colleagues kind of sits in an oversight position, where we're watching what's going on, we're supervising what's going on, and working with coming up with a plan of action for what we can identify as the problem issues and how to address those problem issues. And then from the persuader, who again is experienced in dealing with issues like this, we get feedback. This is the issue. We got a bad supervisor. Like, for example, we had a client up in Burbank back in December. And the issue at that time turned out to be one bad supervisor. And she just wasn't doing a good job. She was alienating the employees. And so we got through that process. The union, I think it was the machinists, never wound up filing a petition, but eventually they made a change in that supervisory role and got rid of, that potential problem. So a persuader comes in, and tries and does work with the employer and the employees to run the campaign. So if there ultimately is an election, you put your best foot forward through the campaign to try to convince the employees that we don't need a union here. So that's what typically happens when you believe a union is at your doorstep.
Yeah, so they need to take action. And again, there are a lot of great employment attorneys out there. And they could probably assist with this, but my recommendation is if you do have a union, you need somebody who's really well versed. I mean, with the labor side of it, because there's a lot of intricacies, and it definitely is its own beast. But real quick, last question for you. If you mentioned that if they present to the company that, hey, we have all these cards, we think it's the majority, we want you to say there's a union. If it is a micro union, they go to the manager and they say, hey, you've got 10 employees, we have 7 cards here, so we want you to say that you have a union here. If the manager admits to it, says, yeah, boy, we've got 7 here. Yeah, that's the majority of my department, but I need to go talk to HR about this. How strict is this? So if the manager's admitting, yeah, you got enough cards here, but boy, I got to go talk to somebody, is that admission enough to put potentially a union in that department?
Yes, it can be.
Okay.
And
So,
that's a
yeah,
very good point that you raise. And that's part of the training that
yeah,
should be provided to supervisors. And basically, what they're trained to do is if an employee or a union representative walks up to you and wants to hand you something, don't accept it.
yeah.
Because that acceptance could be deemed to be legally could be deemed to be an acknowledgement of receipt and knowledge that the union does represent a majority of the employees.
Okay.
So that's part of the training is, to inform the managers and supervisors, sorry, but I'm not authorized to accept anything. And then if the union representative says, well, this is a petition signed by a majority of the employees, they want us to represent them. the response is, well, then you should file that with the National Labor Relations Board and follow the process that's in place for an election. But I'm not authorized to accept it. So that is a very important point, and part of the training that is provided, that we would provide, or a persuader would provide to supervisors.
And the union reps are trained on how to get managers to accept this, especially lower level supervisors. So you got to be on your feet about this. Okay.
Yeah,
Well,
yeah.
Rich, again, you know what? You're making me worry now. My blood pressure's gone up a few points on this. I think, there's so much of a fight back on this administration, and because of, again, we do have a larger percentage of entitled employees than we have in the past. I'm hoping people who have listened to this do take this seriously. And if you have any questions, again, you can find Rich's information on the email where we got this link. But Rich, any final words of wisdom for the team?
Well, I don't know about wisdom, but some final words
You got
is
something to say, though.
yeah, no, and you kind of hit the nail on the head, that by referencing, the concept of entitled employees. And the pendulum in the 45 years that I've been practicing law, and I can't believe I just said that, um, has really swung. In the old days, um, it was more balanced, if not leaning more towards employers and management. But over these many years, both in the labor arena that we're talking about here today, and in the employment arena, with our basic, laws, employment laws, have swung considerably here in California in favor of employees, in favor of unions. And you could settle employment cases in the old days for less than five figures, under $10,000. Um, that's history, my friend. If you can
That's
settle
not
for
even
six
that doesn't even
figures,
get you a seat at the table. 10,000 now,
yeah, it
right?
doesn't. It doesn't. So, yeah, and so, in closing, I mean, a couple other things just to mention that we might anticipate from the NLRB is a change in the joint employer status. Under the Obama and Biden administrations, it was much easier to make a finding that McDonald's Corporation and the individual franchisee are joint employers,
Hmm.
because McDonald's Corporation has a certain degree of control over the operation of the franchisee's franchise. And
Hmm.
and so that, and the beauty of that, if you will, for the union and or the employees, was a deeper pocket, right? Because we had McDonald's
Right.
Corporation as
Yeah.
opposed to this franchisee. We expect there's going to be a change there with that, and go back to a standard that more looks at the facts of control, as opposed to, coming to a conclusion almost automatically that the that there is a joint employer relationship.
Okay.
The other is, I mentioned this earlier, is handbooks. And I think there's going to be a more of a hands-off
Good.
approach by the Trump NLRB on handbooks. And basically by hands-off, what I mean is there's going to be lesser prosecution by the NLRB of alleged improper policies and statements in employee handbooks. So
Good.
I think, Michael, it's going to be changes like that we can anticipate going forward with the Trump administration over the next 3+ years.
Okay. Okay. So you lower my blood pressure again. Thank you. Appreciate it.
Dr.
Okay.
Falcone to your
Yeah.
rescue.
Okay, so Rich, again, thank you so much. You're always I love chatting with you about these things because again, I deal on the employment side. I don't really deal with labor, but I always learn so much from you. And again,
Great.
anybody you need a good attorney, not just labor, but if you need a good employment attorney, Rich's information is there below. He can help you with anything. I've sent a number of clients to him in the past. He's always taken great care of them. So Rich, thank you so much for your time. And at some point, I'm going to get you back on for a real webinar keep you for a full 90 minutes and go in depth on some stuff. So
That'd be great.
I appreciate your time.
You bet, Michael, and yours as well. Thank you.
My pleasure.